Right. Good morning, everybody, and welcome to our webinar this morning that discusses whether you're making lawful wage deductions and some practical tips when doing so. So the webinar today is being presented by myself, Miriam Mitchell. I'm a partner at Ashcroft Mitchell McGregor, and I'm co-presenting today with our immigration partner, Shush. If you want to say a quick hello.
Hi everyone, I'm Shush. I'm a partner at Ashcroft Mitchell McGregor. Back to you, Miriam.
Thank you. So just a couple of housekeeping things to start with, just to let you know that we are recording today's session. A copy will be made available if you need that. There is a Q&A function at the top of the screen if you want to pop in as we go throughout our webinar today to insert your burning questions, and we'll have Alice, who's sitting in the background here, read those out for us at the end, and we'll have some time to answer questions and have a bit of a chat in respect of anything else that you want to know. Otherwise, we will get going so that we've got plenty of time to move through the material today. As you will hopefully know, we're Ashcroft Mitchell McGregor Workplace Lawyers. We provide a range of services in the employment space, the immigration space, and the health and safety space, and can assist with all matters there, whether it's right through from compliance, your employment agreements, your contractors agreements, policies and procedures. In this space, any documentation that you might need in order to ensure that your wage deductions are lawful, or your ATRs and RSC documentation is correct and best practice. We also run disciplinary and performance management processes and give advice throughout those, restructuring and redundancy, and a lot of work these days in the Privacy, Official Information and Human Rights Act space and immigration, as we've mentioned. So if you need any assistance in those areas, please feel free to sing out to us. In terms of an overview on what we're covering today, we will be talking about the Soapy and Pick Hawke's Bay case, which recently came out from the Employment Court in September and has quite some important learnings in this space, not just for RSC workers, but for any employer who is making wage deductions. We'll talk about the case itself, what were the legal claims there and the court's findings. Then we'll go through what are some lawful and unlawful deductions, whether you're in the RSC space or not. A few rules around how to recover overpayments to staff, as that does happen from time to time, unfortunately. We'll have a discussion about how employment and immigration law matters intersect, and then we'll give you some best practice tips. And as I said at the start, feel free to send through your questions as we go. So what is this Soapy and Pick Hawke's Bay case? Well, we'll talk about the background of the case, the legal claims that were made there and the issues in the court, and we'll talk about what the decisions were and then what this means for employers more generally. So this was a case, it really is a landmark decision in employment law, decided by a full employment court in September this year. The case highlights the complexities around wage deductions, and not just under the RSC scheme, but for employers generally. So who were the parties? Pick Hawke's Bay has been an RSC employer since 2008. It recruits seasonal workers from the Pacific nations, and in this particular instance, it involved 3 workers, Lynn Soapy, Denny Lau, and Mary Lau, husband and wife, who challenged the legality of various deductions that were made from their wages. Those deductions included for the costs of accommodation, travel, visa costs, food, kitchen items, and personal protective equipment, so PPE. The plaintiffs, so that's being Lynn Soapy, Denny Lau and Mary Lau, they argued that these deductions breached several key statutes, in particular the Wages Protection Act, the Minimum Wage Act, and the Health and Safety at Work Act. This case has attracted significant attention not just from the Employment Court, but also from stakeholders such as the Human Rights Commission and Horticulture NZ. It really raised some critical questions about employers' obligations, the limits of consent that can be given by employees in respect of deductions from their wages, and the intersection of employment and immigration law under the RSE framework. Essentially, in conclusion, the Employment Court felt that it was necessary to flag the decision to Immigration New Zealand to provide guidance to RSE employers from making similar errors in the future. So it's a significant step when an Employment Court decides to refer the decision to the Immigration Department directly, which gives a good insight and highlight of how important this case is. So what was raised? The plaintiffs argued that deductions made by PIC Hawke's Bay were not authorised, often reduced their wages below the minimum wage. So specific claims included breaches of the wages protection for deductions without written consent, violations of the Minimum Wage Act for deductions that brought the wages down below that minimum wage threshold, but also for alleged deductions that exceeded the 5% cap for accommodation. The plaintiffs also claimed that charging for PPE breached the health and safety laws and regulations, and they said that consent deduction forms submitted to Immigration New Zealand lacked clarity and did not authorise or deferred deductions or were for deductions for pre-employment expenses such as flights, visas and deferred accommodation. Essentially, an overpayment deduction made by PIC Hawke's Bay to Mr. Lau was found to be unlawful as it was not included in the immigration approved deduction consent form nor in the employment agreement, and the court found the employer failed to follow the statutory processes under Section 6 of the Wages Protection Act. So there were a number of claims then to recap here. Under the unauthorised wage deductions heading, the plaintiffs were arguing that the deductions reduced wages below legal minimum without proper authorisation. In respect to the Wages Protection Act, there were claims that the deductions were made without written consent and proper processes. In respect to the Minimum Wage Act, again, an allegation that there was a breach of the minimum wage, but also this that some of the deductions exceeded the 5% accommodation cap. And it was alleged that the payments for items such as PPE or overpayment or deductions made for overpayments lacked proper consent and statutory compliance. In terms of the decision then, the Employment Court obviously went through, as it does, all of the evidence, looked at the various statutory provisions, including Sections 5 and 6 of the Wages Protection Act and the various provisions of the Minimum Wage Act. The Employment Court, having done so, found in favour of most of the plaintiffs on most of its claims. It essentially ruled that many of the deductions were unlawful, particularly those that reduced wages below minimum wage, that the accommodation deductions in this instance exceeded the 5% cap and or lacked a fixed cash value in the employment agreements, and that these deductions were unlawful. The Employment Court also held that charging workers for PPE was a breach of the Health and Safety at Work Act and various related regulations. And it also determined that deduction consent forms submitted to Immigration New Zealand did not permit deferred deductions or deductions for periods before employment began. So overpayment recovery was therefore found to be unlawful due to non-compliance with the statutory prerequisites, including having sought consent in relation to those deductions. As a result, PIC Hawke's Bay was ordered to reimburse the affected workers and ensure future compliance with employment law and immigration law. As case was in some sense quite a surprise to many employment lawyers, Pitt Hawke's Bay and other industry bodies when it came out. While the law with respect to the documentation that's needed to ensure deductions are lawful has been set in stone for quite some time and is reasonably clear. So, for example, commonplace that deductions can only be made with consent. If you have a general deductions clause in your employment agreement, which many employers do, which essentially says something along the lines of, we may make deductions from your pay for overpayment or in particular situations, then the requirement is before making a specific deduction in reliance on that general deductions clause, employers must consult with employees before making that deduction. So that's a process that's been in place, has been confirmed by the Employment Court, or reaffirmed by the Employment Court, and is generally relatively clear. Otherwise, if deductions are not being made pursuant to a general deductions clause, the other mechanism available to employers is to make deductions pursuant to a specific deduction consent. And of course, that's the process that's involved for RSE employers and workers, whereby immigration requires employers to have clear deduction forms for employees to sign their consent that very clearly set out what the deductions will be made and what the amounts of them and what they will be made for. So all of that process and systems requirement has been reaffirmed by the Employment Court. It's been reaffirmed, really the messaging in respect of that process is ensure that you get it right, because if you don't, there will be penalties in respect that could be awarded against employers in respect of that, and or reimbursements that need to be made to employees. What is new and really surprising, however, from this SOPI Pitt Hawke's Bay decision is the ruling by the Employment Court that the deductions were unlawful in this particular instance because they resulted in the wages, or it resulted in employees receiving less than the minimum wage. So in this particular instance, the RSE workers were paid at or close to the minimum wage, and they earned that money and received it in their paycheck, only that, of course, then by the time they had their minimum wage and their payments for that, and then the deductions, which some of which were even consented for, then resulted in the employee receiving in the hand less than minimum wage. So there was a significant portion of the decision that focused on the legality of that, whether the Wages Protection Act, which allows deductions in certain circumstances, whether that trumped the Minimum Wage Act or whether the Minimum Wage Act trumped the Wages Protection Act. And there was a lot of discussion and consideration by the Employment Court to that particular decision. In the end, it found in favour of the plaintiffs, as I've previously mentioned, and it ruled that the Minimum Wage Act trumps the Wages Protection Act. And so even if there's a process allowed there for voluntary and consensual payments, or deductions, sorry, those deductions will be deemed to be unlawful if, in fact, it means that the employee receives less than minimum wage. That was one of the key issues in this particular case. So what are the key takeaways then from SOPI and Pitt Hawke's Bay? The most important point is that wage deductions must be lawful, reasonable and consented to in writing. They must not result in the employee receiving less than minimum wage. Where they do, then employers will need to consider other workarounds. The Employment Court didn't give any guidance in respect of what other lawful workarounds might be, but in practice that would normally involve asking employees to set up automatic payments or issuing invoices to employees and seeking recovery of costs that employers have forked out on behalf of employees by way of invoice, as opposed to seeking to recover those sums by way of deductions from wages themselves. As I've mentioned, another key takeaway is that the minimum wage overrides other statutes when deductions reduce pay below legal minimum, and overpayments to employees requires written notice, consent, and adherence to statutory timeframes. Another key point here is immigration approval does not exempt employers from adhering to employment law obligations. Not surprising to us employment lawyers, and neither you, Shush, right, when we're talking about this particular case. But I know, speaking to a lot of employers, that that was a surprise to them to find that immigration set down particular requirements in terms of the documentation that needs to be provided under this REC scheme, including to get accreditation and ATRs. And employers were genuinely relying on getting the tick off from immigration that their employment agreements met Immigration New Zealand's requirements, that their consent forms met immigration requirements, etc. However, the messaging from this case is you may have the tick off from immigration to proceed in respect of those documents, but that's no guarantee that your documentation complies with employment law and or immigration requirements. Quite often it's a quick checkbox exercise that immigration carries out. They'll do a high-level review, but certainly approval from Immigration New Zealand does not equate to a guarantee that your employment documentation meets all of the requirements of the Wages Protection Act, the Health and Safety Act, the Employment Act, or the Minimum Wage Act. So important to set that documentation up correctly from the start and have input into that documentation. Also, we recommend that employers document any deductions that they make and conduct regular compliance reviews to ensure that if there are any changes in respect of how and why employers can make lawful deductions, that the documentation is updated to reflect that. Right, let's talk about some key provisions then of the Minimum Wage Act and Wages Protection Act that employers who make deductions should be mindful of. So what's the legal framework? In terms of the legal rate framework, the Minimum Wage Act establishes the legal minimum pay rates for employees in New Zealand, ensuring fair compensation for all workers. And then complementing this, the Wages Protection Act regulates how and when wage deductions can occur, requiring written consent and prohibiting unreasonable deductions. Importantly, the Wages Protection Act operates subject to other enactments, including the Minimum Wage Act. And as I mentioned earlier, that really has been confirmed by the Employment Court in this Sopium Pack Hawke's Bay case. Section 15 of the Wages Protection Act explicitly states that if there is any conflict, the Minimum Wage Act prevails. And in practice, this means the Minimum Wage Act sets the absolute floor for pay. Deductions cannot reduce wages below the minimum rate. And even if a deduction complies with the Wages Protection Act, it becomes unlawful if it breaches the Minimum Wage Act. So what is needed in order for wage deductions to meet the provisions of the Wage Deductions Act? The deductions must be reasonable, clearly authorised in writing, transparent, both in terms of their purpose and their amount, and employers must obtain explicit consent for each deduction, unless, of course, there is a general deductions clause within an employment agreement. There's still a requirement there to consult with before a specific deduction is made. Failure to meet these requirements can result in legal penalties and obligations to reimburse affected employees. And for RSC workers, deductions then must also be clearly specified in the employment agreement and the deduction specific deduction consent forms which are submitted to Immigration New Zealand. Let's have a quick talk about some examples then of what is a lawful versus an unlawful deduction to keep this a little bit more practical. So while I have said that the Employment Court confirmed that the Minimum Wage Act trumps the Wages Protection Act, there are still, however, some particular deductions that can be made, even if that results in the employee receiving less than the minimum wage by the time those deductions are made. And we're pleased to see that the Employment Court had enough sense to see that there were specific deductions that needed to be made by law, regardless of whether wages then proceed below minimum wage. These include deductions like PAYE, KiwiSaver, deductions ordered by the court, and these can reduce an employee's wages or salary below the minimum wage, and employers can happily continue to make those deductions at source. However, voluntary deductions must have employees' written consent and serve a clear, legitimate purpose, such as accommodation or health insurance. But if they reduce the employee's wage below the minimum wage, they aren't permitted. And as I mentioned earlier, employers will need to find some other type of workaround, such as seeking automatic payments from employees or invoicing employees for those costs and requesting payment on invoice. Statutory deductions. There are some statutory limits on deductions, so deductions become unlawful if they exceed legal caps, for example, 5% accommodation limit under the Minimum Wage Act. The work around that is to ensure that if you have lodging or accommodation costs for you that you incur on behalf of your employees and want to pass that on, that you have a specific provision in the employment agreement where the parties have agreed as to the value of that accommodation. So in the absence of an agreement in terms of the cash value of that accommodation, employers will be restricted to only recovering 5% of the accommodation limit. I've already touched on this, but in terms of unlawful deductions, charging employees for PPE is prohibited under the health and safety regulations. That is a cost that employers need to meet. And it is for employers to ensure deductions are documented, consented, and do not reduce wages below the Minimum Wage Act. So hopefully these will give you some great tips in terms of understanding what is permitted and what is not permitted in terms of deductions from wages. Let's move on then to recovering overpayments. Unfortunately, mistakes do happen for employers. There are situations in which overpayments are at times made to employees. So let's have a chat about those. The legal requirements for overpayment recovery is such that Section 6 of the Wages Protection Act talks about overpayment recovery under strict legal conditions, and this is to, of course, protect employees. Under the Wages Protection Act, an overpayment usually means wages paid by mistake or for a time that the employer wasn't legally required to pay. So common examples include payroll errors, misinterpreting the employment agreement, or overpaid benefits like annual leave cash-ups. It can also include wages paid during unauthorised absences, strikes, or suspensions. But recovery isn't automatic. Employers must meet strict conditions. They need to show that it wasn't reasonably practical to avoid the error. They must give written notice within 10 working days and then take action within 2 months. Then take action within 2 months and get the employee's written consent or allow an employee to dispute the overpayment. So on the flip side, some things that can't be recovered. Intentional payments like bonuses or money the employee spent in good faith can't be clawed back. And if the recovery would push wages below the minimum wage, that's also unlawful. So in SOPI, the employer made an overpayment deduction from Mr. Lau, one of the plaintiffs, which was considered to be unlawful for the following reasons. First, it was not authorised in the consent form for agreed employee deductions, which meant Pick Hawke's Bay could not rely on his written consent to deduct. Overpayment recovery was not mentioned in the employment agreement that was sent to Immigration New Zealand for approval, and Pick Hawke's Bay also did not comply with any of the steps required in Section 6 of the Wages Protection Act for the alleged overpayment recovery. So this case is a great reminder that documentation and processes are critical to ensuring a lawful overpayment recovery. We've now got a table that summarises the key points regarding overpayment recovery. So looking at the can recover column, you can recover payroll errors, clerical or technical mistakes, misinterpretation of agreements. So if wages are set incorrectly under an employment agreement, for example, using the wrong rate, then the employer may recover. Can recover overpaid benefits. This would include things like annual leave cash outs or parental leave payments issued mistakenly. Wages paid during unauthorised absences, such as a strike or lockout, can be recovered. Then there are some conditions for recovery though, right, that we've already talked about. You still need to bear in mind, even if the type of deduction that, even if the type of overpayment is one that is falls within the can recover category, there are still some conditions that need to be met before you can make a deduction for that overpayment. The employer must notify the employee within 10 days of the overpayment, and you also need to ensure that the recovery or the action taken is then within 2 months, and the employee has been given an opportunity to dispute the recovery. So then in terms of this last column on our summary slide here, there are some clear situations where you can't recover an overpayment. That is where payments are intentionally made. So when it comes to bonuses or allowances, these are typically intentional payments because they're deliberately paid. And unless there's a clear contractual entitlement, any attempt to recover them is generally not permitted and could be seen as retroactively reneging on an agreed payment. Payments, you can't recover money without consent. Even with a general consent clause, employers must still consult the employee before each deduction, explaining what it's for and when it will be taken and how much it is. Employees are entitled to vary or withdraw their consent in writing, is another point to bear in mind. With the employer, then if consent is withdrawn, the employer is then required to act within 2 weeks, i.e. adjust the deduction or stop the deduction within that 2 weeks. Where an employee spends the money, or if overpayments were spent in good faith, employers should act respectfully and transparently, issue clear notices, discuss repayment options, and avoid strict recovery unless a court or employment relations authority directs otherwise. Breaching the consultation rules will mean that employers can't recover those payments. And of course, as we mentioned before, any amounts that would then reduce pay below the minimum wage can't be made. Right, I think this is over to you, Shush, to talk about employment and immigration law intersections.
Cool, thanks, Miriam. So I guess just moving along, one of the takeaways, or the key takeaway with this dual legal compliance is that employers must comply with both employment and immigration laws, including requirements under the Accredited Employer Scheme, agreements to recruit, and RSE scheme at all times. It's not sufficient to comply with just one area and assume there is compliance in another area. So in the SOPI case, as Miriam had set out, the court noted that there will be a crossover of documents and in legal spaces in the employment and immigration space. So for example, here, one of the documents that was approved by Immigration New Zealand was a wage deduction form. The idea is that even though that form is submitted to Immigration New Zealand and it's approved, it doesn't mean that the employer can rely on Immigration New Zealand's approval to meet New Zealand's employment compliance laws. For example, as assessed by the court, the form and the actions that were associated in the case were in breach of the Wage Protection Act and Minimum Wage Act, for example. So the takeaway message is that employers will need to continue to actively remain compliant with New Zealand's employment and immigration laws and should seek legal support in addition to, instances where things have already been approved by Immigration New Zealand, as evident in the case, if employers fall short on trying to be actively compliant and rely on, for example, Immigration New Zealand or EMB's approval, then this can lead to employment and immigration issues, including penalties and potential reputational damage. I guess looking into it, where there is an agreement to recruit and documents, for example, are submitted, just take care because even when those documents are submitted and approved, there can be employment or immigration issues that arise. Miriam, we'll move on to the next slide, please.
Oh, press the button for that. Let's just try that again. Why is that not working? Here we go.
Thank you. So in the SOPI case, there were deductions that were approved under, for example, the agreement to recruit process. They just set out on this slide, and this included where things were particularized in the employment agreement, and the documents were submitted to Immigration New Zealand as part of the ATR application process. As a result, the court had ordered reimbursement, and now notes and correspondence from Immigration New Zealand to employers have been sent around to make sure the findings from the SOPI case are being followed. So this slide just sort of, I guess it just shows some of the things that happened through the ATR process where documents were submitted, but even though there was approval from Immigration New Zealand, that even though, for example, documents were reviewed, that it didn't guarantee compliance with New Zealand's employment or immigration laws. And I guess moving along to the next slide, the important part is that, and I think the most important takeaway is that if you provide any type of financial loan to your migrant workers or any type of financial support, including outside of the RSC space, including to, for example, accredited employer work visa holders, please make sure that the deductions are lawful, because the case law doesn't restrict itself to the RSC space. It also applies, for example, to the accredited employer space, and there will be further sort of wider reaching consequences. So, for example, if you're an accredited employer under the RSC space and also the accredited employer space, and for example, if you have key people associated with that entity that's accredited in the RSC and accredited employer space, then there will be potential consequences for the entity if, for example, if any of the key people have a history of non-compliance with immigration or employment law, and, for example, unlawful deductions would be considered a potential breach and could add to that non-compliance history. So I guess, I'm just trying to, I guess the message and takeaway here is that the SOPI case isn't just restricted to applying to RSC employers and RSC accreditation, but it can apply to also your accredited employer accreditation to support accredited employer work visa holders, and also it could potentially stretch further to keep people associated with entities, for example, that are found to be in breach of, let's say, RSC deductions that aren't lawful. That's all from me in this overlap area. Back to you, Miriam. And we might need to skip a few slides.
Great, thanks, Shush. We are actually normally almost done, so we'll carry on. And where are we at? For some reason, my keyboard has stopped working, but there we go. Wider implications. So let's talk about best practice then. What can you do to ensure compliance and fair treatment, both in terms of not just looking after your employees, but to ensure that you are able to make deductions where you need to protect the business there. So we recommend that you carry out regular review of wage deductions, look at your wage deductions consent forms to ensure compliance with statutory limits, ensure that you are obtaining consent from employees, and where possible, set up specific consent documentation as opposed to relying on general deduction clauses within your employment agreements. Ensure that you are respecting the minimum wage requirements, so avoid any voluntary deductions. And what I mean by voluntary deductions is any deduction that falls outside of the permitted deductions that we talked about earlier, being your PAYE, your KiwiSaver or court-ordered deductions. So avoid voluntary deductions that lower wages below the minimum wage rate and provide legally required PPE. Don't make deductions for PPE is the key message there. Use an alternative method such as invoicing or automatic payments. It's also great to keep clear communication and documentation with your clients. If you are maintaining clear communication with employees, you provide accurate documentation that aligns with both employment and immigration laws, and you are really ensuring that you are managing employees' expectations. That is the best risk mitigation that you can take to stave off any claims. Employees generally are happy to ensure that they are meeting costs that generally fall on them, where that is transparent and they understand upfront at the start of employment that those are costs that they need to meet. So for example, accommodation, these particular costs with respect to visas or health insurance, or if you're providing tools in advance to employees and then asking that they pay those back over time. Those kinds of communications, if they're clear, open and transparent with employees and they know they're going to expect it, it's clearly set out within the documentation. That is normally where employees don't push back or then seek to rely on technicalities in order to get a windfall. Review employment agreements regularly, amend the agreements as needed to ensure that you're complying with lawful deduction. And of course, in order to ensure that you're doing that, carry out internal audits from time to time, or have an external audit to review your documentation and get legal advice to safeguard against non-compliance and employees' rights. So to avoid those pitfalls, regularly review your wage deduction practices and documentation is the key messaging there. And if you need assistance with that, of course, I'm happy to help. So that brings us to a close in terms of the substantive contents that we had, and I'll just move the slides forward. We've got a summary here in terms of how we can assist you further. Otherwise, we will move to any questions that we have got. And Alice, do you want to cover those for us?
Yep, no worries. So we've got a couple of questions. The first one is the 5% accommodation requirement for RSC workers only?
No, it's not. It applies to all employees and workplaces, and as I mentioned earlier, you're restricted to only recovering 5% of accommodation unless you have otherwise agreed the cash value of the accommodation. Now that's something we often get in the farming industry, right? It's a little bit easier there and a bit different because the best practice if you have got farm accommodation is to also have a service tenancy, and that is covered by the Residential Tenancy Act, and is different. There's differences between boarding, lodging and actual when the Residential Tenancies Act applies. Can be the subject of an entire separate seminar, so I won't go into the details of that, but essentially we are providing boarding or lodging that applies. It doesn't apply where the Residential Tenancies Act applies.
Fantastic. And with overpayments, can you please explain adhere to statutory timeframes?
Oh, yes, absolutely. So these were set out at slide 15, and I'll just flick that so that we've got that in front of us. So written notice must be given within 10 working days of the overpayment having been made, and then you need to act in terms of recovery within 2 months. So hopefully that answers your question there.
Wonderful. And then the last one is, if we invoice the employee for the cost of goods services supplied, can they authorise us to deduct set amounts from their pay each week to repay those invoices?
No, if they would breach the minimum wage provisions, you will need to rely on employees making a payment from their bank account to you to meet those invoices. And so there's not really, if you're going to invoice an employee, you will still, even if the invoice itself won't give rise to the right to make the deduction. So that's the first thing to note. If you're going to invoice employees and then want to rely on deductions from wages in order to ensure those invoices are paid, you will still need to ensure your consent documentation is set up correctly with respect to those deductions. So get a specific consent deduction form signed by an employee where they agree for deductions to be made from their wages to repay that invoice over time. That's generally going to be a requirement there, regardless of whether you have the invoice or not. But even then, if you have the invoice and you have the consent deduction and all of your documentation is correct and the employee is on board and they voluntarily want to be making want you to be making those deductions from the wages, if it would result in the employee receiving less than minimum wage, then no, you still can't be making those deductions. So yes, fine, invoice your employees, have that consent documentation set up and have those deductions made over time for those employees that are paid well above minimum wage. But for the ones that are at minimum wage, unfortunately, what this particular case means is that employers are stuck with invoicing their employees and then asking the employee to make a payment back to the employer. Sounds ridiculous. It honestly is a kerfuffle, right, in respect of how practically the relationship works, but that is what the Employment Court has ruled. The Employment Court did give consideration to the fact that the parties were essentially, or there was an argument by the lawyers within the case to say, look, if that is the way that the Employment Court goes in terms of its decision making, that essentially disadvantages both employers and employees, because it's an extra step, it's an extra admin step that employees need to go through to then make a payment back to the employer on the back of those invoices. And it's not an ideal world and not one which I would say the majority of employees are happy about, let alone employers. The answer for the Employment Court essentially was, well, that's it. The legislation provides for this and we're stuck. The answer to that lies in parties making alternative arrangements or ultimately Parliament coming to the party and changing the law. Watch the space though, I say, because I do know the decision has been appealed, so the Employment Court may yet have a different view. Any other questions? Now's your chance to quickly pop up your Q&A little chat box and ask us why you've got us captured, and have the expertise available for any other burning questions or things that you need assistance with. So to give you a little minute to pop up your last questions, any final closing remarks or comments from you, Shush?
No, I think if it's anything, it's just that if you have migrant workers in the RSE space and accredited employer work visa space, just take care, because immigration and employment requirements apply across both spaces, and any breaches in the RSE space or accredited employer work visa space will sort of will be counted as a breach across employment and immigration laws, including unlawful deductions. And if for example, breaches in the RSE space, this can negatively impact your accredited employer accreditation in the accredited employer work visa space. That's the takeaway from me.
Great. Thank you, Shush. That is a really great tip. And I see that no one else has popped up any further questions in the Q&A or raised a hand. So hopefully that was relatively clear for all of you today. Feel free to touch base with us at the after this presentation if you need specific advice in this area. We've worked through Soapy and Pick Hawke's Bay. We've been working with particular orchards and their RSE requirements, and other employers who aren't working in the RSE space but who are affected by this decision. So feel free to reach out to us for any further help that you may require, or specific questions that you have. Otherwise, I'd like to thank everybody for taking the time out of their day today to attend and coming to hear from us, and I wish you a great day. Great, thank you, bye-bye.